I want to take this opportunity to welcome you to the closing session of the 2012 TEI International Tax Day. Just by way of introduction, my name is Liz Johnson. I'm a partner with Wilson & Partners, PwC's affiliated tax law firm, as well as a member of PwC's Canadian National Tax Services Group. I've got with me today my colleague, David Glicksman, who's also a partner with Wilson & Partners and a member of the Canadian National Tax Services Group. And we are joined by Rick Bisquero, who is also a member of PwC's Canadian National Tax Services Group. I think we actually managed to get Rick's name on the slide. If you look at the material, you'll see a picture of Bill Nakano, who unfortunately was not able to travel from the West to be with us today, and Rick kindly agreed to step in. So thank you, Rick. Many of you will be familiar with Rick and have heard him speak at previous TEI events. Before he joined PwC in 2009, he was the director of the International and Trust Division at the CRA Rulings Directorate and a member of the CRA GAR Committee. Rick's experience as a senior official at the CRA gives him a unique perspective on issues that are top of mind for the CRA, and we'll wrap up with some of his thoughts. In keeping with tradition, this final session is a review of case law developments over the past year, including a heads up on some cases to watch that are still making their way through the courts. We will look to Rick to bring us up to date on CRA priority issues, GAR statistics, and to share his insights on how the CRA is likely to view some of the recent judicial developments. In some ways, the case law update will contain familiar material. For the past few years, cases like Velcro, Garon Trust, and Copthorne have been making their way through the courts, and it's only during this last year that we've had the final chapter. As you all know, the international landscape is changing. The tax authorities in many countries are testing the limits of judicial willingness to address what is perceived by some to be abusive treaty shopping. The cases we will touch on today involve various anti-abuse tools that have met with more or less success in the Canadian courts: beneficial ownership, corporate residence, and the GAR. The courts have given us some guidance, but it is probably still limited at this stage. The message so far, in our view, remains that with attention to detail in execution of a plan that depends on treaty residence and beneficial ownership being established, the Canadian courts are loath to interfere. However, there are some clear open issues, including the extent to which so-called surplus stripping transactions are susceptible to attack under the GAR, and the role of artificiality and economic reality when it comes to the application of the GAR. So with that, I'm going to turn it over to David to do the first segment of today's case law review.
Okay, thanks very much, Liz. Good afternoon, everybody. As Liz mentioned, I'm going to talk about a couple of cases and really looking at a couple of methods by which CRA, in addition to the GAR, has available to it to challenge what it considers to be inappropriate or abusive treaty shopping. And so I'll be looking at the cases dealing with beneficial ownership and residence. We'll start with beneficial ownership and look at the Velcro Canada case from a tax court decision from earlier this year. Velcro is the second Canadian case on beneficial ownership in the international context. Prévost Carr, which was a 2009 decision of the Federal Court of Appeal, was the first. It dealt with a dividend flow as opposed to Velcro, which dealt with royalties. The taxpayer was successful in Prévost Carr. There was always some concern that because of the legal differences between dividend payments and the declaration of dividends and entitlements to dividends versus contractual payments such as royalties, that there may be different decisions forthcoming. However, as we'll see, the taxpayer was successful in Velcro. Now, the background to Velcro is that you can see from the slide, there was an arrangement between VCI, Velcro Canada, and Industries, which was a Netherlands company. whereby the Canadian company paid royalties to Industries for the use of know-how. Those payments were subject to withholding tax, 10% under the treaty. Those payments were made before 1995. In 1995, the Velcro Group reorganized, and Industries continued into the Netherlands Antilles, and the royalty arrangements were revised such that the agreement was assigned by Industries to Holdings, which was a Netherlands company, and effectively Velcro Canada paid royalties to Holdings, and Holdings then paid royalties to Industries. In 1998, there was a change in the treaty. The royalties were now fully exempt, and the CRA challenged the arrangement and claimed that Holdings, the Netherlands company, was not the beneficial owner of the royalties, primarily because of the back-to-back or the alleged back-to-back arrangements. Now, the court, and again, this was a tax court decision. The Crown did not appeal this to the Federal Court of Appeal. The court in Velcro very much followed the decision in Prévost-Carr, looked primarily at the domestic interpretation of beneficial ownership as opposed to an international or treaty-based interpretation, and it looked at the issue, four main factors to determine beneficial ownership. In addition to looking at beneficial ownership, the court had to consider whether there might be an agency or nominee relationship, or whether Holdings might be treated as a conduit company. When the court looked at the evidence, it determined that Holdings was the beneficial owner of the royalty payments. It looked at a number of factors. For example, there was no automatic flow of funds up through the chain to Industries. The payments that were received by Holdings were commingled with other funds of Holdings. Holdings had currency risk. There were different currencies involved. It also had creditor risk in that it had no priority over any other creditors of Velcro Canada with respect to the flow of funds. The payments themselves through the chain were not of identical amounts, and so the court looked at all of those factors and determined that Holdings was in fact the beneficial owner of the royalty payments. The court also determined that Holdings was not an agent or nominee or conduit. In terms of the agency argument, the court found that it was not able to affect the legal position of Industries, and that pretty much put to rest the agency argument. It was not a nominee in that it acted on its own account, and in order to be a conduit, the court determined that it would have to have had absolutely no discretion as to the use of the funds, and again, that was not the case. So in looking at those factors, the court found that Holdings was in fact the beneficial owner, was not an agent, nominee, or conduit, and so the taxpayer was successful. And it's interesting, around the same time, I think that decision came out in the early part of the year. In April of this year, the OECD put out a draft revised commentary on beneficial ownership. That draft was subject to a number of comments and some fairly heavy criticism from the international community, and a revised draft was released last month. There is a comment period till December 15th on drafting issues. And it ties into some of the issues discussed in the Canadian cases in terms of sort of the lack of any clear or common understanding of what actually constitutes beneficial ownership, particularly where you have different jurisdictions, common law countries, civil law countries, very difficult to come up with a common interpretation. We've seen in Canada that the domestic law seems to trump any international treaty-based context. In the draft commentary, beneficial ownership generally seems to be interpreted in a treaty context, not limited to domestic law interpretation. The key issue in terms of distinguishing beneficial ownership from other types of arrangements is that the recipient of the funds should have the right to use and enjoy those funds or the payment that it receives, and should not be constrained by any contractual or legal obligations to pass the payment on or forward that payment on to another person. Now that begs a number of questions as to what that means. There's a number of examples given in the commentary, but it's still not clear. The commentary provides that the obligation must be related to the payment. Again, begs the question as to what is related versus unrelated. Obligations are generally based on a review of the legal documentation, but may also be inferred from surrounding facts and circumstances, which again leaves it very unclear because you're looking at a sort of in substance whether the recipient has the right, in addition to what the legal rights and obligations are, what the, this is in substance what the recipient has, is able to do with the payment. And I think at this point I'm going to ask Rick Bisquero to comment on, when you look at this, Rick, when you look at Velcro and you look at the OEC draft commentary, where you think the agency's sort of coming out, how it would view a case like Velcro, whether it's good or bad from a CRA perspective, and also what do you think the impact of the draft commentary will be on future Canadian cases?
Well, I think first with Velcro, I don't think the agency is very happy about losing a case, but given that that's 2 in a row, lost Prevost, lost Velcro, I think the agency has no choice but to accept the decision and be happy that it finally has some clear guidance on what the term beneficial ownership means in the treaty context for purposes of Canada's treaties. And this is notwithstanding what the OECD is doing right now with respect to revising the commentary. I would say, though, that the losses will not deter the agency from going after beneficial ownership issues. I'll just make a comment with respect to what the agency said at the recent, not so recent, but the May IFA roundtable in Ottawa, when they were discussing the beneficial ownership issue. The agency said that it would look at all the surrounding facts and circumstances. So they accept the cases, but they're still going to look at all the surrounding facts and circumstances. And this struck me, was a comment that they made that they would look at the ownership issue with a view to determining the degree of discretion that an entity has over the control and use of an income stream that's paid to it. So they're not giving up, they're not throwing in the towel. Now turning to the OECD commentary, the agency does use the commentary, I can tell you that as a fact, relies on it to interpret treaties, and this is something that I used to do when I was with rulings, and people in my division would do that. But we looked at the commentary as a guide. Primary tool we used was jurisprudence and, of course, policy. So although the agency will rely on any new commentary that comes out for guidance on to interpret the term beneficial owner, I think there's some things that we have to take note of. First of all, when you look at treaty interpretation, this latest commentary can only be used to assist interpreting the existing treaties if it is not significantly different from existing commentary. So when you look at Prevost-Carr, when the court went through the decision in Prevost-Carr, it looked at existing commentary and said, gee, this isn't helpful, so where do you go? Well, looking at the treaty says if a term's not defined, you go to domestic law, and that's what it did. So the agency will follow that kind of route. It will look at the commentary and then end up in domestic law simply because the commentary generally is not sufficient, and now because we have Prevost-Carr and Velcro decisions, I think the agency is bound by the law. I think I'll leave it with that, David, in terms of whether the commentary is helpful. After Indo Foods came out, I don't know if you were all familiar with that case several years ago, and it wasn't a tax case, but there was a lot of talk within government after Indo Foods, which dealt with this issue of beneficial ownership in a different context, and it was a stovepipe transaction where there was no control over the payments. To try and adopt that case to bring an international meaning to the term for treaty purposes in taxation, and that didn't receive a lot of support in Canada. And when we look at what's going on with the discussion around the latest OECD commentary, there's a lot of disagreement, and David alluded to the different jurisdictions, common law versus civil law. In Canada's treaties, if you have a treaty partner that's a civil law jurisdiction and you start talking about beneficial ownership, they don't know what that means. So if you try and use commentary to define the term, obviously your treaty partner is going to say, no, just a minute. We don't agree. If they've made a reservation to the commentary, we pretty well can't use that to interpret the term. So then you come back to, at least if you're the Canadian fisc, you come back to domestic law, and you have Velcro and Prevost-Carr.
Okay, thank you, Rick. It's interesting when you look at undefined terms, as Rick is saying, and you look at the Treaty Interpretation Act from a Canadian perspective, despite whatever the commentary says, we may just be looking at domestic interpretations of a term like beneficial ownership. So we're going to move on to look at another tool, I guess, that the agency has in terms of treaty shopping, and that's the issue of trust of residence, and in this case, trust residence. And so we'll look at the case of Guerin Trust, which was a decision of the Supreme Court of Canada earlier this year. And we can see in this case, we have a simplified version of the facts. It's effectively an estate freeze of the OPCO. The shareholders froze in favor of family trusts. The family trusts were established in Barbados with a Barbados Trust Company as trustee. It was an indirect freeze. The trusts held shares of, subscribed for shares of Canadian holdcos, and the holdcos held the shares of the OPCO. Now, in a fairly short time period, the shares appreciated significantly in value, and the trusts sold the holdco shares to an arm's length purchaser and realized significant capital gains, and claimed that the gains were exempt from Canadian tax by virtue of the treaty that these trusts were resident in Barbados. Now, there's been very little jurisprudence on trust residence over the years. There's really one significant case called Thibodaux, which was a 1978 decision of the Federal Court Trial Division. On the facts of that case, the federal court determined that a trust, in that case at least, was resident in the jurisdiction where the trustees resided, or the majority of trustees resided. In what was arguably obiter comments, the court indicated that the corporate test of central management and control was not the applicable test for trusts. It was never been entirely clear. People have taken over the years that statement almost as gospel, but in fact it's never been entirely clear. And in Guerin Trust, that was challenged at every level, the tax court, Federal Court of Appeal, and Supreme Court of Canada. At the tax court, the judge found that there was no reason really for the trust residence test to be different than the test applied to corporations, and found that Thibodaux was not sufficient authority in order to reject that principle. The court found significant similarities between trusts and corporations, and found that it was appropriate to apply the same test for residence to both trusts and corporations. The Barbados trustee on the facts of this case was found really to be an administrator, that the key decisions were made not by the trust company but by the beneficiaries or proxies of the beneficiaries. And the court found that the trusts were in fact resident in Canada based on that central management and control test, and could not claim treaty benefits. Now, those findings were upheld on appeal at the Federal Court of Appeal and at the Supreme Court of Canada. There were some other issues raised, a number of other issues raised in Guerin Trust. Just to mention a couple of them. They're interesting because the tax court and Federal Court of Appeal dealt with them, but the Supreme Court did not. There was an issue around Section 94 as to whether the trusts were deemed, notwithstanding they were foreign to Barbados with the Barbados Trust Company as trustee, given the involvement of Canadians in the trust, whether Section 94 would deem those trusts to be resident in Canada. At the Tax Court of Canada, the court found that Section 94 did not apply. However, the Federal Court of Appeal found to the contrary, but also found that the treaty overrode and that the Barbados residents would engage the treaty provisions. As far as the GAR was concerned, which was again argued at both the Tax Court and Federal Court of Appeal, both the Tax Court and the Federal Court of Appeal found that, assuming that the trusts were resident in Barbados, that GAR could not be used to override the treaty, and that relying on the treaty exemption that had been negotiated between Barbados and Canada was not abusive if the residence test had been met. Now, in the Supreme Court of Canada, the court did not deal with these issues. It did state that its refusal to comment should not be understood as an endorsement of the Federal Court of Appeal position. So it leaves it open for another day as to whether, in fact, the Supreme Court might come to a different conclusion, for example, as to the potential application of GAR in these circumstances. Now, from a taxpayer perspective, one thing that's helpful about this case, although the taxpayer lost, is that if you actually sort of take heed of what the court said and you look at the facts in that case, if you do plan your affairs properly and you implement it carefully and you continue to monitor it and make sure that things are still appropriate, it may still, it's still clearly possible to structure something and have the residents of the trust or other entity you're dealing with in the right jurisdiction. Rick, I guess I'm curious from your perspective, if you put your agency hat back on, what the department's or the agency's takeaways would be from this case.
Well, I think first, David, substance is an important issue, and it always has been for the agency, and I think that's what Garon Trust speaks to, is the substance of the transactions that were undertaken. It's nothing new for the agency. By that I mean, notwithstanding the Thibodeau decision, the agency always had the position that the trust could be resident where the management and control of its assets was located. So that's actually in one of their ITs. So they never gave up after Thibodeau Trust trying to prove that a trust was located elsewhere than where the trustee was, and it was all factual. Garon happened to be the first case where they had the evidence and the facts to support that the residence of the trust was somewhere other than where the trustee was located. So if I put on my agency hat and I look at the case and say, well, what are you going to take away from that? Well, one, the agency is going to have more confidence now than ever before in challenging offshore trust structures. And I can tell you that I've seen lately, over the last year and a half or so, in cases that I've been involved with, the first issue that the agency goes after in the offshore trust is the residence issue. So they're looking at it very, very closely. What's good for it in them? Well, they finally have a court saying that trustees must carry out central management control of the trust property and perform the duties under the trust indenture in the location in which they are resident. Also, if the agency sees letters of wishes or a protector appointed, if they see any of that kind of stuff around an offshore trust, alarm bells right away. Even more so than ever, they'll start digging into it. What's the bad thing for the agency to take away from this? I think that's the GAR issue. Whether you're a trust or any kind of person or entity and you establish bona fide residence in a treaty jurisdiction, I think the agency is going to have a great deal of trouble trying to apply the GAR to deny benefits to the particular trust or entity or individual, absent the law provision in the treaty. So I think Canada is going to have to start working on putting more LOBs in their treaties on a go-forward basis.
Okay, thanks, Rick. Liz, I'll turn it back over to you.
Well, for those of us who work extensively with the LOB provision in the Canada-US treaty, that's not good news. I'm going to just cover, hopefully fairly briefly, some highlights in the GAR area in the past year. I have to start with Copthorne, although we've all heard a lot about Copthorne. This is a Supreme Court of Canada decision that was finally released in December of last year, almost a year after it was argued. Some of you might ask, well, what more is there to say? Because there was certainly a lot written on it after it was released. However, it was an important case, not only because it was the fourth Supreme Court of Canada decision on the GAR, but also I think we're seeing, as it's applied in the cases that have followed on Copthorne, I think we're seeing some slightly new principles developing. We're probably all familiar with the facts. The case involved alleged surplus stripping. There were two chains of investments. One was a cross-border investment that was made by an individual named Victor Lee into a chain of Canadian companies that you can see on the right-hand side of the slide. And ultimately, the Canadian investment made down this chain turned out to be a bad investment that was sold at a loss. There was a second cross-border investment chain that involved Victor Lee's father, who invested into the company on the left-hand side of the slides. that made a profitable investment in a Canadian hotel. Through a tax plan that clearly worked at a technical level, a reorganization occurred which was essentially intended to permit the losses in the Victor Lee chain of company to be used against the gain on the hotel in his father's Canadian company. To facilitate this, the first-tier Canadian company owned by Victor Lee, which was called VHHC1, sold its now virtually worthless investment in the second-tier Canadian company, VHHC2, to his father's Canadian company, Copthorne 1. So at that stage, and I've sort of shortcutted this in the slides, VHHC2 was a wholly owned subsidiary of Copthorne 1. However, instead of carrying out a vertical amalgamation to access the losses in VHHC2, the shares of that company were moved out from under Copthorne 1 so that the two companies were sister companies and a horizontal amalgamation was done. This allowed the preservation of the paid-up capital of VHHC2, which originated, if you like, in cross-border paid-up capital at the VHHC1 level in the amalgamated company. And at this stage, the evidence was that there was no specific plan to actually use that paid-up capital, but it was, if you like, preserved. Several years later, there was a further transfer of the shares of, and I believe that should actually say VHHC1, and of Copthorne 2 to a related Barbados company, and there was then yet another amalgamation of those two entities to form Copthorne 3. In this amalgamation, the result of the technical application of the rules was that the paid-up capital that had been preserved in the amalgamated company then flowed through to combine with the paid-up capital in VHCC1 to be included in the paid-up capital of Copthorne 3. This paid-up capital was then used in a share redemption to extract cash from Canada as a tax-free return of PUC, unless, of course, the GAR applied. So there were two very important issues before the court. One was whether the earlier intergroup share sale and amalgamation, which simply preserved the PUC, was part of the series that included the later transaction in which the PUC was actually used. Counsel for Copthorne urged the Supreme Court of Canada to revisit its earlier conclusion in the 2005 Collius case that the term "in contemplation of" could be both a forward-looking and backward-looking test. However, the court had no patience for the argument that its early analysis should be revisited. It was satisfied that the later transaction in which the PUC was used took into account the preservation transactions and that there was more than adequate nexus to associate them for purposes of the extended definition of a series of transactions. The second and more interesting issue was whether the preservation and duplication of PUC achieved through the planning was abusive. No doubt the Crown would have liked the court to have found that there was a broader policy in the Act against surplus stripping. However, in the 2005 original decisions of the Supreme Court on the GAR in Trusco and Collius, the court had found that no GAR assessment could be based on an overarching policy. Rather, GAR could only apply if there was a policy that was grounded in the provisions of the Act itself. The court said something else that was significant and that in the subsequent decisions the lower courts have been trying to come to grips with. It said that there were two approaches to statutory interpretation. One was a basic approach when interpreting the provisions of the Act in a non-GAR context, And here it is, as we all know, necessary to conduct a textual, contextual, and purposive interpretation exercise. When it came to the GAR, the court said, in effect, it was necessary to do all of that, but then it was necessary to add on another layer of, I guess, what I would call extra deep consideration of the provisions, perhaps set in the larger context of the Act as a whole. This doesn't mean looking for an overarching policy. Rather, it's necessary to determine whether there's a scheme that can be discerned from the rules in the Act that has an underlying rationale that is offended by the particular planning. Now, on the particular facts of this case, the court looked at the amalgamation rule in Section 87, which deals with the determination of the paid-up capital of the of an amalgamated company, and the court found that in a parenthetical provision in that particular rule that requires the cancellation of the paid-up capital of the shares of a subsidiary held by a parent company on a vertical amalgamation, a scheme that, when taken into consideration with other rules, such as those in 212.1, could be said to show an underlying rationale against the duplication of cross-border PUC. The court found that that underlying rationale was abused by the transactions in question and that the GAR applied. The difficult question that we're left with as a result of the analysis in this case is trying to discern where to draw the line between an underlying rationale and an overarching policy. And I think some of the other cases that I'll cover today will demonstrate the difficulties and the challenges there. Now, these so-called value shift cases don't involve cross-border planning. They're purely domestic transactions, but we included them not only because we think they're important GAR cases, and they represent the post-Copthorne landscape. I think they're significant as indicators of how the courts are approaching the search for an underlying rationale in the provisions of the Act when they're looking at the GAR analysis. So there were three cases. The facts are pretty similar in all of the cases. In each case, there was an existing Canadian company that had realized a capital gain, or in the case of one of the cases, the global equity case had just income that it wanted to shelter. And in the planning, the company with the gain or income transferred assets that did not have an accrued gain to a NewCo and took back common shares with full basis. A stock dividend was then paid on the common shares in the form of preferred shares having low paid-up capital and high redemption value. The result of the way that the rules applied was that the value effectively was stripped from the common shares and was transferred onto the preferred shares. The preferred shares had low basis, but the basis, the high basis in the common shares, was unaffected by the stock dividend. This was followed by a sale of the common shares to a trust of which the beneficiaries were related to the shareholder of the CanCo. Under the affiliation rules, as then in effect, the trust was not affiliated with the corporate transferor, and if the relevant rules were the capital loss stop rules, those rules did not apply. Not surprisingly, the CRA applied the GAR and denied the loss. In the case of Triad Jesco and the number company, the gain that the taxpayer was trying to shelter was a capital gain, and therefore the loss that was claimed was a capital loss. In the global equity case, the taxpayer actually filed the loss as an income loss, and the CRA did not contest that. Now, again, I just want to come back to the Copthorne decision, where the court had made this point that the court had to find an underlying rationale in the provisions of the Act itself and not look to some kind of more vague policy in order to determine whether the GAR applied. In the two capital loss cases, the Tax Court of Canada found that the GAR applied, although the two decisions, which were written by different judges, came at the GAR analysis slightly differently. In the global equity case, Justice Woods of the Tax Court found that the arguments that were made by the Crown, which were analogous to the arguments that had been made in the other two cases, simply didn't hold water because the loss had been claimed as a regular business loss, and therefore there had been nothing put forward to her to prove what underlying scheme of the Act had been abused. Therefore, in the tax court, Justice Woods found that the minister did not succeed on the GAR in the global equity case. In the Federal Court of Appeal, not surprisingly, the Tax Court of Canada's decisions in the capital loss cases were upheld. Here, the court largely adopted the reasoning of the tax court in the numbered company case. The court found that it could discern a policy from the capital loss rules in the Act that losses should be real and economic in order to be available to offset gains and should not just be paper losses. Interestingly, the court did not find it necessary to find this policy in a repealed provision aimed at prohibiting the deduction of artificial losses, although it did seem to find the repealed provision somewhat relevant as part of the legislative history. Quite importantly, in my view, the Federal Court of Appeal confirmed in the Triad Jesco and the number company case that the fact that the affiliation rules were subsequently amended in such a way that the trust in question would have been affiliated and the stop-loss rules would have applied did not give rise to an inference that a policy to that effect was in place before the amendment. And I think this is an important point because there is some case law that would suggest that subsequent amendments can be relevant to the GAR analysis, but the court seemed to say here that that would only be relevant if the amendment was done to close a blatant loophole, and apparently did not look at this planning as involving a blatant loophole. The most important of these cases, I think, is the global equity case, because here, despite a last-ditch effort by the Crown to argue, as it probably should have in the first place, that the loss was a capital loss, the focus was on whether an abuse could be found in the absence of any demonstrable scheme of rules, such as the capital loss stop-loss rules. So here the decision was reversed, whereas the tax court had been unable to find that the Crown had demonstrated abuse adequately. The Federal Court of Appeal found that there was an underlying rationale when applying the general rules applicable to the computation of profit. Now, these are just the rules in sections 3 and 9, and they're very general indeed. The court found that it could see a rationale in those rules that only real economic losses should be brought into account. Some argue that this case comes as close as we have to a court adopting an economic substance approach to determining whether the GAR should apply. In my view, we should not conclude so quickly, although it's clear that the CRA may be emboldened by the words of the court in the decision. I do think that the court was grappling with the Crown's inadequate approach in not earlier asserting the capital nature of the loss. And secondly, a general sense of offense at the artificial nature of the loss. Throughout these decisions, the court refers to this planning as involving paper shuffling. But again, looking at Copthorne, we see the court did work hard to find an underlying rationale in rules as basic as those in sections 3 and 9 against losses that result from paper shuffling. So the last GAR case I'm going to mention, because I know we want to move on, is a case called Spruce Credit Union. I do note this case was appealed to the Federal Court of Appeal last week, which presumably means that the Crown's not very happy with the decision. It's an unusual case in that in many GAR cases, the taxpayer will simply concede tax benefit and avoidance transaction and concentrate on the misuse or abuse argument. Here, however, the main argument was that there was no avoidance transaction, and this argument prevailed, at least at the tax court level, which meant that the tax court did not need to consider the misuse or abuse, and in fact did not go on to discuss that, although sometimes that does happen. The case involved a large number of credit unions. In British Columbia, as I understand it, the credit unions were required to pay into 2 arrangements that offered a form of CDIC equivalent insurance coverage to depositors. So in one of the arrangements, which on the slide is noted as CUDIC, the payments were to a government-owned entity, and in the other case involving STAB, the payments were made to a corporation that the credit unions actually were shareholders of. A change in the regulatory environment required that funds that were held by STAB end up back with CUDIC, and a means had to be found to effect that transfer. I'm not going to review the technical rules that apply to credit unions, even if I understood them. We don't really have the time. Effectively, there were 2 ways that the credit unions could have received the funds from STAB so that they would have the funds to pay over to CUDIC. One was for STAB to pay the amounts as refund of premiums, and the other was to pay a dividend. STAB chose to pay a dividend. The credit unions included the dividends in income and claimed the 112 sub 1 deduction. The CRA argued that the GAR should apply, that this was inconsistent with the basic scheme of the credit union rules. But the court, to cut to the chase, found that there was no avoidance transaction. There was a single transaction involved, the payment of the dividend. There were 2 alternatives considered. One was to pay a refund of premiums. The other was to pay a dividend. But the primary purpose of either of these was to achieve a transfer of funds from STAB to its members. Therefore, there was no avoidance transaction. There was nothing that was primarily tax motivated. Simply deciding between 2 alternative steps was not in and of itself a transaction. So, subject to the fact that this case is being appealed, I think what one might take away is that in a very simple situation involving a single step, perhaps simply an exit from an investment, the fact that there's an overall business purpose may make it very difficult for the Crown to assert that there's an avoidance transaction, even though the taxpayer chooses the most tax-effective way of accomplishing the transaction. However, we all know that there are few transactions in the world that involve a single step, so it'll be interesting to see what happens to this case on appeal. Now, just to note, I've included in our slides some cases that are, some cases we've been watching, one of which recently settled, some of which are still working their way through the courts. The one that settled, I'll just note, is a case called GTE Venezuela. We've talked about this, I think, in prior presentations. It did involve alleged surplus stripping that the CRA said was subject to the GAR, and we were hoping, of course, that it would proceed to trial and have a good outcome and provide some useful guidance on the limits of acceptable versus abusive surplus stripping, but it did settle, and there are no details concerning the nature of the settlement. So with that, I'm going to turn it back over to Rick to wrap up.
CRA hot topics. I'm not going to talk to them all. I'll just talk to a few of them and then quickly go over the statistics slides. Surplus stripping. Liz just finished mentioning the GTE Venezuela case. That was a very important case for the agency, and sadly it got settled, so we won't know what the outcome would have been. But surplus stripping is a very, very hot issue with the agency. It has been for the last several years. I would think that as a result of Copthorne, there will be even more attention given to the cross-border surplus stripping type cases. And the agency will closely review and challenge plans to create, increase, or as in Copthorne, preserve PUC. I will say, though, that several years ago, while I was still with the agency, we undertook a review of policy behind surplus stripping, PUC issues, et cetera, on the domestic side and on the international side. And we came to the conclusion, and we did this study simply because there was an issue before the GAR committee that had to do with a cross-border surplus strip, and it involved public companies. We came to the conclusion that in a case where you have a foreign entity that's looking at taking over a Canadian target, typically the entity's got two choices. Either buy the Canadian shares directly, and if the Canadian shares have low PUC, too bad, or you set up an acquisition co, you stuff it with cash, shares in the acquisition co have high basis, high PUC, and then the acquisition co buys the target and amalgamates. The issue is whether or not that second plan with the acquisition co offended the scheme of the act with respect to PUC. And we came to the conclusion, no, that's good. And why is it good? Well, personally, I thought it was okay simply because that's the Duke of Westminster. When you can have the choice to go down two paths, and you take the one that's most tax efficient, good for you. And I think the agency has accepted that. Hedging, I'm bringing that up because this is something new. Not new in the context that taxpayers hedge transactions, but new in that the agency is starting to have a look at it. And they have two concerns with respect to hedging. One is that it's a true hedge, and they look at income versus capital. But the other one is more interesting. The second concern, and to my mind, the more interesting one from the agency standpoint, is that the ability to use hedging to move gains and losses around within a multinational group. This could cause some concern. So just be aware, like if any of you are involved in hedging transactions and you get the notion that you're going to use a hedge to move a loss into a jurisdiction to offset, say, FAPI, could be a bit of an issue. So I'll just leave it at that with respect to hedging. Debt dumping, this was a particularly hot issue for the agency quite a few years ago. It's now essentially been plugged with the foreign affiliate dumping rules. But it's still a hot issue simply because the agency is not giving up on the pre-foreign affiliate dumping rule transactions. They're still going after them. And from what I understand, with some vigor. Unfortunately, in one particular instance where the agency had looked at investment in pref shares where there was an interest deduction, and I'm talking about the tax avoidance people, had a look at it. They agreed it was okay, no problem, we won't assess. So the 2 years they looked at, they didn't assess. 2 or 3 years later, they come back for a second audit, and the new audit team takes it on and decides they're going to assess. Well, the agency has a policy in place that says if you've looked at something and you should have or ought to have known that it was wrong from an agency standpoint and assessed it, well, when you come back at a later year and you look at it again, well, we're not going to assess it. In this case, they are assessing the years subsequent to the years that were originally looked at. So for the years they looked at, they're applying their policy. For the years subsequent to that, they're not applying their policy, but the taxpayer didn't unwind the transactions simply because the agencies told them it was okay. So this is something to be aware of, and to me, it's contrary to agency policy. However, it's indicative of the mood out there with respect to the agency and how it's approaching issues. It's being very aggressive, and I suspect that the senior people in the agency have been told to collect the cash. We need cash to pay down the deficit. Treaty shopping, something that was front and center with Velcro and Prevost Car. That is still a very hot issue with the agency, and it will be for some time to come. And typically when we talk about treaty shopping, at least from the agency context, we're looking at moving into a treaty jurisdiction to get better rates, Part 13 rates, better or zero. And we're looking at moving into a treaty jurisdiction to get an exemption from capital gains. Now, the agency usually comes at these issues with a three-pronged attack. One is beneficial ownership, which we have been talking about. The second one is residency, which Garron has dealt with. But a caution there, after the agency lost MIL, we came out with a, it was either after or before, I don't know, because I was involved in writing it, but age is catching up to me. We wrote a income tax technical news dealing with residents and what was termed resident of convenience. And the agency will accept residency, I mean physical residence in a jurisdiction, as long as there's a substantive economic nexus to the treaty country. And that's where this residence of convenience issue comes in. So be aware of that. And I can tell you that in the context of that particular ITTN, the Tax Legislative Policy Group in Finance was heavily involved with it. And of course, the third tool to attack treaty shopping is GAR. And that's in spite of losing MIL and in spite of losing something like Garron, when Garron speaks to the ability of GAR to challenge quote-unquote treaty abuse. Royalties, essentially a transfer pricing issue, and the agency again is being very aggressive there. And I think I'll just stop with that because we get into transfer pricing, and in particular, you know, the agency has this view that, well, okay, we're going to disallow the entire royalty payment simply because, you know, the technology that you're using, it's not worth anything anymore. So we'll disallow the whole royalty payment. I mean, all of this stuff is factual. Again, what we're seeing here, though, is money's crossing the border. I can recall as a young tax avoidance auditor, and we're going back a lot of years, one of the seasoned veterans in the Montreal Tax Services office telling me, when I went out there for a visit, he says, Rick, he says, you know, the basic rule of thumb around here is you follow the dollar out of the country and you'll always bring some back. So that's what the agency is doing more aggressively these days, and royalties will not be any exception. And the last hot topic that I'll deal with is, or talk to, would be business restructuring and closure costs. And in the context of business restructuring, this issue wasn't touched on directly, but indirectly by David Swenson this morning when he spoke of intangibles, and that was the #1 transfer pricing issue. Well, for the CRA, it's a very, very hot issue, sale of intangibles to related companies. And their view is that a reasonable businessman, okay, would choose to license the intellectual property rather than sell it. I don't know where they're getting this view, but that's their view. And maybe it's grounded in the OECD transfer pricing report that was issued a few years back that said that a company wouldn't sell its crown jewels. Well, nobody really knows what a company would do, but it's nice that the agency is trying to put itself in the place of a businessman. However, that's something to be really concerned about with respect to their approach to sale of intangibles. And the other thing is closure costs. And the agency taking the view that it's the parent company that's dictating the closure of a Canadian company or a Canadian branch, and so the parent company should bear all the costs. So the agency's view is to deny all the costs. GAR stats, a lot of GAR cases, 75, 76% the agency has accepted. When we look at the GAR issues, make just one comment with respect to the GAR issues. It shows to me the importance of the issue to the CRA. So if we look at what's at the top, it's surplus stripping. Kitty tax, well, I haven't dealt much with that, but loss creation via stock dividend, I can tell you I was heavily involved in those. And look at the ratio of accepted to non-accepted. I think this is something that's instructive here. In the loss creation schemes using stock dividends, you got 91 accepted, 0 not accepted. That tells you the agency attitude towards the issue. And for the GAR committee, the importance of the issue to the GAR committee, but really the strength of the case. And that goes to the jurisprudence, the facts, and the documents to support their position. So when you look at these GAR issues, look at it from that standpoint. How many were accepted and not accepted? Case in point, if you go to the second slide and you look at, I think it's interest deductibility, or it's on the first slide, sorry, interest deductibility. 36 cases, 19 accepted, 17 not accepted by the GAR committee. So you got a 50-50 chance on interest deductibility, which is better than surplus stripping. And I think with that, I'll pass it back to Liz.